ready to get started. My name is Sally Ryder. I'm director of the Rehnquist Center. I want to welcome you all here today on behalf of the Rehnquist Center. I want to thank the student chapters of the American Constitution Society and the Federalist Societies for co-sponsoring this event today. But mostly I want to thank the three Rehnquist Center fellows who have helped to put this program on: Brian Mosley, Daniel Arianas, and most especially Andrew Floyd. They're the brains behind this. They've from conception to execution. And without further ado, I want to turn it over to Andrew. Thank you.
Thank you, and first of all, thank you all for coming. I know it's a rainy day out there, but I'm glad that you're here. About a year and a half ago, I went to a wedding of a friend, and I sat down at the table, and the guy next to me introduced himself as the Associate Dean of a law school, and I just finished my first year of law school, so we started having a great conversation. And he told me about this idea he had for ending the Electoral College and how he thought he could do it in a constitutional manner. That conversation ended up spurring an entire wedding's worth of conversation and some bickering back and forth among the guests at our table. So I thought it was such an interesting conversation that I'd like to continue it in a more public forum. So just to introduce your two speakers here today. First on the left here is Vikram Amar, that was the wedding guest that I met. He's the Associate Dean for Academic Affairs at UC Davis. And at the time I didn't really know who he was, but he's actually quite a distinguished speaker. He got his undergraduate degree from UC Berkeley. He got his law degree from Yale University. He then went on to clerk for Judge William A. Norris at the Ninth Circuit. And from there, he went on and was a clerk for Justice Harry Blackmun at the United States Supreme Court. He's a national expert in constitutional law, and he writes a bi-weekly article on justia.com. Also, he told me last night that he played football at Cal. So
play is an active verb.
Yeah. And our other speaker on the right is Michael Paulsen. He's a professor of law at the University of St. Thomas. He went to Northwestern for his undergrad, and he got a JD also at Yale Law School. He also got his master's in religion at Yale Divinity School. And he's written over 50 articles on constitutional interpretation, and that is his specialty, including two that I found the article titles to be very interesting. One called Let's Mess with Texas, and Is West Virginia Constitutional? So if you could welcome them with a round of applause.
Well, I'm starting off. I'm very happy to be here. Very much appreciate the work of the Rehnquist Center and the graciousness of our hosts. The Federalist Society, yesterday I got to speak to some students, and now this wonderful event today. It's great to be able to spar with my old friend Vikram Amar. Something left out from the introduction to Vik's big brother, Akil Amar, and I were accidental law school roommates. When I showed up as a transfer student, and his anticipated roommate failed to return because he instead was going on to be a TV anchorman in Miles City, Montana. I needed a room, he needed a roommate, we were thrown together, we've been good friends ever since, and that's how I met Vik. First of all, when he was still a young pup of a Yale Law School student, and I was visiting my old roommate. It's great to be here in Arizona to debate this. I was at first reluctant to come. I mean, no, not that reluctant, because it was 12 below in Minnesota day before. So I was always looking for opportunities to get out of Minnesota. But I was reluctant because I wasn't sure there would be that much conflict between our positions. Okay? Supposedly, he was introduced as being on the left and I was on the right, and I think that's where we are politically. But on constitutional issues concerning the Electoral College, I'm not sure there's a huge amount of difference, but I'm going to try to generate some. I'm going to do the best I can to produce a little bit of conflict. The title I gave my talk, and there's a cute little red handout so you can follow along and see if I'm making all my points, is the Electoral College and the National Popular Vote, Confessions of a Conservative Skeptic. And I am a skeptic, but as to both the Electoral College and somewhat as to the National Popular Vote plan. I'm sort of a moderate critic of the Electoral College. I think in the end, ultimately, I'm not a big fan of the Electoral College system, but I do see many of the political and structural federalism virtues to it, So I don't think it's all bad. Still, I won't be a full-throated defender of the Electoral College. I'm similarly a moderate skeptic on the National Popular Vote Plan. I actually like the idea. I like the idea of using the existing Electoral College system in order to generate, through the collective action of states, a national election. I think it's clever and interesting and intriguing. I do see some problems with it, and I'll sketch those out. We'll have time to talk more about those in debate. But first of all, part of my job serves as a warm-up act for Vic, and explain just a little bit about the Electoral College. Now, this is very much familiar turf to many of you, but here are the three core features, as I see them, of our Electoral College system. First, it's election by states. The states choose the manner of the selection of the electors. So it's election by states through the vehicle of selecting electors, and according to a prescribed apportionment rule that gives each state a certain number of electoral votes, keyed to the addition of its number of senators and number of its representatives. So those are the three key features. It was election by states of electors according to this prescribed apportionment rule. The third one is, what the apportionment rule is. I'm actually a pretty big critic of. The second one, election by electors, has pretty much in our system become pretty much obsolete. Electors are kind of a pass-through by and large, and mostly it's just a system of just accumulating electoral votes. But as to election by states, I can actually see some good in it from a federalism perspective, which is appropriate for the Rehnquist Center for studying constitutional issues and structural federalism. The virtues of federalism, as applied to the election for president, are kind of the virtues of federalism generally. Decentralization and divide and control so as to thwart popular strict majoritarianism on the theory that that will produce, over the long haul, better government. We are a nation of states, a compound republic, not a simple direct democracy. And the Electoral College preserves a role for the states as states in the election of the president, much the same way that the Senate preserves a role for the states as states. As Madison put it in Federalist Number 39, our system is partly national and partly federal. States can serve, and the structure of federalism can serve as a valuable check on national institutions. And furthermore, this again is, you see my reference to Madison's Federalist Number 10. Federalism for the framing generation was seen in part as an important mechanism for control of faction. Okay? Madison explains that there's a concern about minority faction interests, special interest groups grabbing all the power, and that that's adequately dealt with by the Republican principle of majoritarianism. But then in Federalist Number 10, he addresses the issue of what do you do about majoritarian factions, where a majority is overpowered. And the solution that is our structural system of federalism is that you divide the society into disparate groups, okay? And that you require collective action building on the majorities you obtain within these different areas, so that you control factions of the majority by dividing the population and having the president and the Congress respond to different constituencies so that it acts as a check, as a brake. And I see some considerable virtue in that. And the way that's reflected today with the Electoral College is, I think, two ways. First, political scientists would say that candidates now must appeal to diverse constituencies. They can't just pile on votes and obtain a national majority by focusing only on their voters or concentrating strictly on urban areas or rural areas. So I see a virtue in that. And the second one comes from an insight from mathematics and Gates theory. Okay, now don't let your eyes glaze over. But here's the theory, is that mathematically, what the Electoral College system does is it tends to value most highly the median voter in the median state. A lot of people's objections to the Electoral College, and to some extent it's mine too, is that it renders a lot of people irrelevant. Right? I live in Minnesota, a deep blue state, and I'm a red voter, so my vote never counts. Vic lives in California, a deep blue state, and is a blue voter. Nobody appeals to him either. Right? Texas, nobody campaigns in Texas because it's solid red, doesn't make any difference. Arizona, pretty darn red. Nobody campaigns here, so you're treated as irrelevant. And you know, I think even Governor Brewer was reported as saying, you know, this isn't an exact quote, but I think she said, "Yeah." Nobody pays attention to us. Now, there's a virtue in that too. You're not inundated with television ads. My folks live in Wisconsin, right, and they're besieged with television ads. But think about this concern about WAF, which I identified, has a flip side to it. And that is that the divide isn't red state, blue state. The divide created by the Electoral College system is red and blue states that aren't contested versus purple states, right? The Electoral College system tends to focus more attention on politically integrated and diverse states as opposed to homogeneous states. Now, the way in which that can be a virtue is that it requires candidates and national parties to appeal to the middle. It is a check against extremism because, as a functional mathematical matter, the parties have to steer their pitches more toward the middle. It promotes consensus. It promotes moderation. It promotes stability. You might even say it tends to promote domestic tranquility. Okay. Now, the flip side of that, the downside of it, is it sometimes means that the popular vote winner can be the Electoral College loser. Historically, we have some instances of that. 1876, 1888. I'm still upset about the 1888 election. And some people are upset about the 2000 election, where George W. Bush did not have as many popular votes but won in the Electoral College. Arguably, 1824 was this way too, but not every state was using elections, so we can't really tell that Andrew Jackson sure had more votes than John Quincy Adams when he was going to the House of Representatives. But the short point remains is that there can be a result where the national popular vote loser is actually the Electoral College vote winner. I think that is a real problem. I have some problems with it, but I also wonder how much of a problem is that really? It really is just a different federal system for accumulating majoritarian votes. And the analogy of it is to baseball. Okay? Any baseball fans here? The 1960 World Series. Now, probably a few of you remember that. It's actually before my time, too. But in the 1960 World Series, the Yankees were playing the Pittsburgh Pirates. Okay? World Series is structured best of 7 games. You win 4 games, you win the World Series. The Yankees, I looked this up last night. Wikipedia is a great thing, isn't it? The Yankees outscored the Pirates 55-27 in runs scored. But their runs were all bunched in the games. They had a couple of blowouts. Okay? And the Pirates won narrowly, and in the 7th game, Bill Mazeroski hit a walk-off over to win the World Series for the Pittsburgh Pirates. A great upset. Okay? Do we regard that as unfair? Do you actually think we should have, for the Baseball World Series, if we just play, let's see, 7 times 9, 63 innings and see who scores the most runs over the course of 63 innings? It's a different, you know, it's just not the way the system is structured. We structure the World Series in terms of discrete outputs. Who wins discrete games? You can see the Electoral College as a 50-state game. You play a 50-game season of political baseball, and the winner of the most weighted 50 states is the winner. It really doesn't seem to me quite that problematic a system, or I think the concerns that some people have are a little bit overstated. But they're not all that overstated, right? I've been talking about the good, now I'll talk about the bad. In the end, I do think that the Electoral College has some very bad features in that it is anti-democratic, right? In a representative democracy, it really ought to be the case that the guy with the most votes, or the gal with the most votes, wins. Okay? It strikes us as unfair to come out the other way. And I share that intuition. I asked my 14-year-old girl about this, and she said, most votes wins. That's the correct rule. I asked my mom, my 78-year-old mom in Wisconsin, what the rule should be. And she said, well, if you have that system, the Democrats will win the coasts and the large cities, and they'll just ignore the middle of the country. And I said, well, Mom, but if more people are in those cities, shouldn't most votes win? She says, no, that's wrong, because they'll ignore our interests entirely, which, if you think about it, is kind of James Madison's intuition. So my mom and James Madison are like two core great political theorists. But I do think that's a problem. More of a problem yet is the fact that the representation system, key to senators and representatives, grossly overvalues small states. Small states are much more overrepresented, just as they are overrepresented in the Senate. So that's the bad side of the Electoral College. Then there's the ugly. The ugly comes from the Constitution's history of formation of the Electoral College. When they're devising this system, like a key speech was James Madison's speech on July 19th, where he said, in principle, I favor direct election to the president. And many of the Federalists were on that side. He said, but there are a couple of problems with that. One is that the franchise differs state to state. The North, the franchise is much more diffuse. More people get to vote. That would count their votes more heavily. You might ask, well, why shouldn't they count more heavily if they franchise more people? But then his real clincher of an argument is if you have direct voting based upon who gets to vote in what states, we won't get any credit for our slaves, as we do under the 3/5 compromise, which counts the allocation of representatives based on the number of persons in each state, plus 3/5 of such other persons, which is the circumlocution for slavery. This 3/5 compromise gave the South a huge and disproportionate representation advantages by virtue of the number of slaves they had. They could vote their slaves. So, for example, Virginia had fewer free citizens in Pennsylvania, but 5 more representatives, and as a consequence, 5 more electoral votes. In the election of 1800, Jefferson beats Adams on the strength of the difference of the enhanced slavery bonus for the southern pro-Jefferson states. And I think historically that's a big problem. Okay? 32 of the first 36 years of the Republic, our president is a slaveholder in the South. I think 12 of the first 16 presidential elections go to slaveholders. Now that's gone now, and I think to some extent the ugly history lying behind the Electoral College system is behind us, right? And so it has to be evaluated on its virtues now. But that's the good, bad, and ugly. Let me just say 2 words about the National Popular Vote Plan. Vic will explain in considerably more detail. But what it is like each state in an agreement says we will give our electoral votes to the national popular vote winner. And it's a device whereby the states so agreed can essentially team up and award the presidency to whoever wins the national popular vote. It's sort of using the Electoral College structure of federalism in order to create a national election. I think it's clever. I think it's ingenious. I'm very attracted to it. And I think it's perfectly constitutional, because the Constitution says that the manner of selection of electors is up to each state. Each state gets to choose the manner. And if California wants to say our manner of selection is whoever wins the national popular vote wins our Electoral College votes, I think that's perfectly fine. The next step, the power of contingent legislative action, is if California wants to say, but we're only doing this if enough other states go along to make a majority so it actually works. I think that is within their constitutional power to prescribe the manner of selection of delegates. Finally, though, the question is whether you can make such an agreement enforceable and binding. I think, and I'm sure we'll discuss this more later, that in a matter of constitutional law, the autonomy of each state to choose the manner of its own selection of electors cannot be contracted away. Okay? It is an inalienable constitutional right. And you see this actually in a judicial opinion of Chief Justice Rehnquist in his concurring opinion in Bush versus Gore, harking back to earlier Supreme Court decisions, including one I know here, McPherson versus Blacker, where the Supreme Court said that the power of a state to choose the manner of its election of electors may be reclaimed at any time. It's a plenary constitutional power. I think then that in the end, you can't make an agreement with other states that would bind you not to change back in your electoral college system. I think that poses some problems for the National Popular Vote Plan, but not necessarily insuperable ones. So I'll let Vic say his shtick, and then we'll go on to debating the merits of this proposal.
Thanks, Mike. And thank you all for having us here. And thank and the center for inviting us. It's a distinct pleasure to be here. I come to Tucson, you know, every year or two for some reason or another, and it's always nice to be here. I wore my U of A colors today, actually. Even though I used to teach at UCLA, I didn't have a lot of loyalty to them. Because Cal lost UCLA, and Cal would be slightly better off if UCLA accumulated some losses. I'm rooting for the Wildcats. I'm also happy to be here at an event sponsored by the Rehnquist Center, because the year I clerked for Justice Blackmun, I got to know the former chief a little bit, and I thought he was a thoroughly delightful guy. He was a very nice, collegial, jovial man. I remember once, you know, there were 33 clerks in the building, and he probably couldn't get to know very many of them outside his own chambers. But out of the blue, one day he grabbed me in the hall, and he told me that he thought that the draft that that Justice Blackmun had just circulated in an opinion that I had helped Justice Blackmun work on, he thought that was one of the best opinions he'd seen drafted during the year. So, and William Rehnquist was nothing if not a talented writer. So that was high praise indeed. I'm happy to be here also because it's a pleasure to be here with Mike. He's really one of the leading constitutional thinkers in the country, and I always learned from him when I read his stuff and hear him talk. And then finally, I think this is just a really important, interesting topic. So it's a good one to spend time looking at. Let me just say a few words about the Electoral College generally, and then talk a little bit about the National Popular Vote Plan and some of the constitutional issues I see presented by it. You know, I think its origins were tainted a lot by the slavery issue. I think it really was a play by Virginia and other large slave states to make sure that they got credit for their slaves via the 3/5 compromise. I don't think that there are really very strong policy arguments for having it today. And we can talk about the World Series, and we can talk about Mike's mother, who's a lovely woman, I'm sure. But let's just ask, if we were building a country today, would we remotely think about picking our chief executive through this system? No state in the country would ever try to pick its governor by this. And we're talking about big states. California has more people than the United States did for half of its existence almost. And yet the idea that in California we pick the governor by county, it's an odd thing. We don't recommend this to other countries when they're building their constitutions. It really is, I think, largely anachronistic. And you know, it's not to say there could be certain things that cut in its favor, and also there may be a certain value in preserving something that has worked in the main, just because you never know what unforeseen consequences come from change. But I do think many of the policy arguments that are often advanced don't wash. Let me just mention a few of them. One is, and those that sounded partisan interest, I just exclude altogether. So the idea that I don't want to change the Electoral College because it favors the Democrats or favors Republicans, well, that might be true and that might motivate people, but I don't take that as a legitimate basis for an informed discussion of what our system of picking the president should be. I should also say, I think any plan to change things should be structured so as to come online a little down the road when its immediate partisan implications are harder to predict. That's a little way of protecting ourselves from ourselves. You know, one thing Mike mentioned about how the Electoral College helps dampen the extremes and focus on the median. It seems to me if you want a middling median approach, just look at the median voter nationwide. I mean, a simple national election does a much more straightforward, much more predictable, much more effective way of accomplishing that goal. There is a federalism twist to the Electoral College, although people often invoke federalism without defining it. I think when they do get down to the nitty-gritty, it has to do with Mike's mother's concern about you know, regionalism, that you can win by winning certain areas and not other areas. And I guess I'd say a couple things about that. I guess Mike's mom might not be a fan of Baker versus Carr, because that's the way we used to district before the one-person, one-vote principle became a constitutional mandate. And remember, but for the Electoral College provisions in the Constitution, the essence of the Electoral College would violate the 14th Amendment's one-person, one-vote principle. So it's an exception to what we've, since then, you know, constitutionally codified in every other election in the United States that I can think of. But the other thing is, you know, the Electoral College hasn't done such a good job of avoiding regionalism per se. Lincoln won without being on the ballot in all the southern states. Look at the electoral map of the red and blue in the election of 2000 and 2004, 2008, 2012, and in pockets of big lumps of red and blue. It's not a checkerboard. It's a regional thing. And interestingly, if you go back 100 years to the elections at the end of the 1800s, you see the exact same breakdown of states with the Democratic and Republican Party almost precisely inverted. Save for a few states, it's a complete inversion of the parties, but the same regional bloc focus. Now, happily, I actually think that we don't have to worry about regionalism too much in the United States because it turns out that with the advent of political parties, party rather than geography is the most salient characteristic of political identity. So that even in states that are solidly red, as Mike said, like Texas, or solidly blue like California, we're still only talking about 60-40. We're not talking about 90-10. So we actually, whichever way we go, we're going to have a person who's picked who has to represent a broad swath of the population. And I don't think the Electoral College does that any better than a national popular vote. Witness the state popular votes for governors. We don't have this concern that a governor in California represents LA, but not San Francisco and not Fresno. I mean, there's some of that stuff, but there's some of that under any system. And it seems to work well for the governors, even in the big states. Another objection that's sometimes made to eliminating the Electoral College has to do with third-party candidates. And won't elimination of the Electoral College generate a lot more third-party candidates? And there too, I think we should look at the experience of the states. We've had thousands of elections in states, many of them big. We don't have a problem with third parties in state gubernatorial elections. In fact, we've had more third-party interference, if you will, with the two-party system at the presidential level than in Texas, New York, and California combined as states. The short of it is, as French kind of mathematician and political scientist Condorcet would explain, when you have a single-seat election that is determined by a first-past-the-post system of aggregating votes, that's going to produce a stable two-party system. And you only diverge from that stability when you have multi-party bodies, like a legislative body, where seats are allocated proportionally to each party's showing in the election. That's how you generate more third parties to participate. A final thing I'll say, and that has to do with recounts. Some people say, well, if you have a national popular vote, can you imagine the brutality of a national recount? I think that there is a wrinkle here, I'll come back to a little later, about how the recount nightmare under a national popular vote could be bad. But notice that you have a lot of recount problems under the Electoral College that you wouldn't have under the national popular vote. In 2000, who cares how many people voted for Bush in Florida if we went by a national popular vote? Gore beat him by millions of votes. In 2004, George Bush beat John Kerry by 3 million votes, but if Kerry had gotten 125,000 more votes in Ohio, then that would have thrown the election his way. And if it had been not 125,000, but rather 25,000, we would have had a replay of the Florida nightmare in Ohio in 2004. So a lot of times the national tally is clear, but the tally in a few key states under the Electoral College is not clear. So you have more recount problems under the Electoral College. So it's not an either-or thing. And we handle recounts in big states like California, New York, and Texas all the time without too much problem. So I don't think that's a reason to be fearful of a move as well. So how did the NPV plan kind of come to us today? As is often true, I was wrong about how the country would react to a result in 2000 where the popular vote winner and the Electoral College winner were not one and the same. I thought that would prompt more of a backlash and an outcry. And in my own defense, I'll say, but for Bush versus Gore, which kind of was a distraction, maybe more people would have focused on that anomalous aspect of the... If Bush had clearly won in Florida, so he clearly won the Electoral College, so there was no dispute there, then people might have said, well, wait a minute, should we have a system that leads to this result? But because everyone fixated over Florida and Bush versus Gore, it kind of took us away from that for a while. In any event, my older brother who teaches at Yale, who was, as Mike said, his law school roommate, and then a guy at Northwestern, the former dean, Robert Bennett, separately but coincidentally, wrote some essays in 2001. And it turns out that people had planted seeds of this idea even in the 70s and 80s, although they hadn't developed it. So I don't want to say that we're the only ones who've ever thought of this. But we put it out there in a much more structured format, Robert Bennett and my brother and I, whereby, as Mike pointed out, because Article 2 gives to each state the discretion about how to allocate its electors, that if enough states, actually as few as 11 states, if they are the right 11 states, could essentially circumvent the Electoral College by giving the full contingent of their Electoral College complement to the national vote winner rather than the person who won the most votes in those particular states. So California would say, we give our 55 electoral votes to the person who got the most votes nationwide, regardless of whether that's the same person who got the most votes in California. And if the biggest 11 states did that, then because collectively they comprise more than half of the Electoral College, that would guarantee that the national popular vote winner wins the Electoral College. So it's not eliminating the Electoral College, it's just interjecting something in the Electoral College that guarantees that the winner in the Electoral College is always the national popular vote winner. But the problem was one of coordinated action. Why would California risk giving its electors to someone who lost the state if other states aren't going to agree to do that? And it may end up generating a president who is not California's choice when enough other states haven't signed on to this yet. So that's where we suggested that states could coordinate by making their adoption of this approach, whereby they give their electors to the national popular vote winner, contingent on enough other states agreeing to do so as well. This is 2001. Some law professor's pie in the sky. It's not going anywhere. I mean, come on. I write essays all the time that I think are brilliant and that I think are interesting and clever and all that. And Mike does too. He's one of the most brilliant, clever people I know. But they don't typically go anywhere.
Widely ignored.
So in 2006, a computer scientist, not a lawyer, at Stanford, a guy named John Kozo, put some of his own money, and he got someone kind of at the other end of the political spectrum from him to put in some of his own money, I think, a decent-sized amount of money, to wage a grassroots, state-by-state campaign to introduce to state legislatures a template form of this kind of plan. And they formed an organization, and they got a lot of Republicans as well as Democrats. So Fred Thompson, former senator from Tennessee, who was a Republican nominee for president, a former Republican Illinois governor, a bunch of Democrats and Republicans came together. They compiled this excellent source book. I really recommend it to you. It's called Every Vote Equal. It answers most every objection to the plan, including some of the ones that Mike alluded to that we'll talk about. And they started shopping this thing in legislature. And lo and behold, they now have about half of the electoral votes they need to make this come online. They have 9 states plus the District of Columbia, and when California came on board, that got them to almost the halfway point. So other states that have done it are Washington and Delaware and Hawaii, and thus far the problem is that only blue states have joined. No red state has joined, even though there are a lot of Republicans on the organization, and even though some Republican legislators and governors, e.g. Jan Brewer, have mentioned this, or have advocated for this, there's still a perception, I think a wrong perception, but a perception that the Electoral College favors Republicans and hurts Democrats, because it favored Bush in 2000. again, I told you in 2004 it could have easily gone the other way with Kerry winning because of the Electoral College. But there's this perception that Republicans don't want to move away because this is something that helps them win presidential elections more than they otherwise would. That's why in California, Schwarzenegger vetoed the bill twice after it passed California's legislature, and it's only after Jerry Brown became governor that California signed on. Because there's this national Republican sense that this is not a good thing for the party. Let me just flag a number of constitutional questions that have been raised. I think each of them has compelling answers. I don't want to eat up too much time going into them, but then I'll throw it back to Mike to talk a little bit more about some things on his mind. One objection is, well, isn't this circumventing the Constitution? Isn't this an impermissible way around what the Constitution says? And I say, it's not a way around it at all. Each state is given the power to do it. It takes full advantage of the autonomy states have to decide for themselves how they want to allocate electors. And there's lots of other aspects of the Constitution that we take for granted today that came about by a similar kind of creative working within the constitutional system to kind of get around some of its uncomfortable elements. Let me just give you one. You know, we take for granted today that senators are elected by the people of every state, not the legislatures thereof, as provided for originally in the Constitution. And the 17th Amendment ultimately enshrined that in 1913. But the 17th Amendment came about only because a huge number of U.S. senators were already directly elected by the populations of the states. Why? Because a number of states, including Oregon, they, as a matter of state constitutional law, required the state legislature to pick as U.S. senator the candidate who was most popular in the most recent statewide election. Okay? So they effectively accomplished direct election by twisting the arms of the state legislatures. And that's how we came to get the 17th Amendment. Another objection is that, well, since every state has different voting rules, isn't there too much disuniformity among the states to satisfy Bush versus Gore's requirement of equal protection? And I don't think that is a problem either, and I will get into that if you want to, but there's no disuniformity within each state. So no state would be denying any person within its jurisdiction the equal protection of the laws. But we can come back to that. There's another set of issues concerning delegation. And Mike kind of adverted to this. Can you delegate the power to pick your electors to some larger group of voters outside of your state? I don't see any reason why you can't make a compact on this kind of an issue when you can make a compact on every other kind of issue that states have sovereignty over. And I think that the Chief's concurrence in Bush versus Gore has nothing to say about that. That was about whether the state courts in Florida could disregard what the state legislature wanted, not whether the state legislature itself could decide to proceed by a manner that might involve looking to people outside of the state legislature, as they do now when they take into account the views of the voters, not just themselves. I'll mention just two more. One is whether this kind of compact requires congressional approval under the Compact Clause. And I am not sure that it does, but I think that the current plan is flawed in certain respects, and I think we need congressional approval to make it more sensible in any event. So whether congressional approval is required as a matter of the Compact Clause or not, I'm much more comfortable with this plan if Congress does approve it. And then let me just stop there and turn it over to Mike to talk a little bit about some of his more particular concerns.
Okay, I'll try and keep this brief because the questions will be the most interesting.
Indeed.
I agree with tons of what Vic said. And I actually think that the National Popular Vote Plan is entirely constitutional. It is not a violation of federalism. It is an application of federalism. It is states using their autonomous constitutional power to prescribe the manner of electors in order to achieve the results they wish. And I think there's absolutely nothing constitutionally wrong with that. So I'm with him. I don't buy this argument that this subverts the Constitution. It is merely an ingenious illustration of the constitutional system. You give the states, it's an application of state power. So I don't see why, in principle, either why Republicans or conservatives or constitutional conservatives should oppose it. Let me talk just a little bit about the compact clause issue and explain that and unpack that a little bit and tell you what my views are. And I said when I opened that the power of the state to choose the manner of its electors is a constitutional power that is not waivable, can be reclaimed at any time. Okay? The states have the absolute power. I don't see this so much as a problem of delegating that power to someone else, as opposed to, can a state make a binding contractual agreement to forfeit its constitutional power? I think the answer to that is no. States can make deals and agreements with other states on certain matters, and sometimes the compact clause of the Constitution, guarding against states sort of teaming up and forming confederacies and stuff like that, requires congressional approval. But I think it is a structural principle of separation of powers and federalism that prevents a state from giving away its state citizens' core constitutional powers. And there's actually a very, almost directly on point Supreme Court case for this. Some of you law students may have had this inflicted upon you in your constitutional law courses. New York versus United States. It had to do with agreements interstate over who gets all the radioactive waste, right? And it was in part a compact clause case, and in part a case where Congress was coercing states to adopt particular laws. The issue that came up was, well, have the states, by agreeing to the compact, waived the structural protections of constitutional federalism? And the Supreme Court, in an opinion by another great Arizonans, Justice Sandra Day O'Connor, said that you can't do that. Federalism is not, it's not the constitutional right of the state that it can bargain away. Federalism exists for structural reasons to protect individual citizens' liberties. To the extent that the Electoral College system is designed as a structural safeguard of federalism, I don't think you can make a compact. Okay? Now, I'm not sure this would make a huge amount of difference. It would mean that California cannot legally give away its power to change back. Okay? But suppose the national popular vote legislation adopted in each state says, we hereby adopt this if and only if it can be a binding limitation on other states. If it can't be a binding limitation on other states, then I think that state's system has sort of self-imploded. Right? They've purported to, now it would be a matter of interpreting each state's law. But interesting, what a mess it would make. To make it more interesting yet, these national popular vote state legislative bills contain this interesting severability clause, saying that if part of this enactment is unconstitutional and invalid, the rest stands. Well, that's kind of peculiar if they say we do this if and only if we can bind other states. But this is severable. It's really hard to know whether it's severable or not. You could have potentially a lot of issues about whether states have adopted this at all. And I think that's the real collective action problem, is the constitutional uncertainty of doing it. And that might be something you fix by just having the states adopt different versions of this, because there's nothing wrong with the state saying, we do this if other states have done it, as long as that state always retains the power to opt out. So I think that is that's the real collective action problem. I'm going to conclude with a question for Ben,
okay,
because I share some of these concerns about the electoral
college.
Let
me answer what you just said first, and then you give me the question as I leave. So, first of all, the actual agreement, the template that the states have signed on to, doesn't really make each state's adoption of this statute explicitly conditional upon the enforceability with respect to other states. It just says, this agreement shall take effect when states cumulatively possessing majority of the electoral votes have enacted this agreement in substantially the same form.
But it does prohibit them from withdrawing.
It does. And that brings me to the second point. It's true that states cannot give away their right to change their mind. But that's true under any agreement they make. What states can do under the Compacts Clause, the court has said in dozens of cases, is they can agree to particular notice provisions and timelines to implement their change of heart. So that's all this does. It says, not that you can't change your mind, but that you have to give 6 months notice before a change is effective. And if that can be done for all of the other states' sovereign powers, the power to regulate land and water within its domain, the power to control, to exercise the police power, I don't know why this is distinctive. And let me say, there's no single case in the U.S. Supreme Court where it's ever struck down any compact on the ground that it involved a power that cannot be subject to an enforceable compact, and it hasn't even struck down any compact on the ground that Congress hasn't approved it, even though it's hinted that congressional approval is required. It's never seen a case where it says we're not going to enforce this one because it required approval and approval was not obtained. So I need, and again, there's a chapter in the book that talks about dozens of cases in which the court has talked about the different kinds of things where states are free to compact, all of which involve the, quote, sovereign powers of the state. All of which involve things that the state has the power to do that the federal government would otherwise have no ability to coerce or manage. Now, New York versus the United States is an interesting example, but I think if it were a pure Compacts Clause case without a federal statute that imposed the take title provision, then I don't think it would be the same thing at all. Congress passed a law that went beyond, in providing for specific sanctions on states, that went beyond anything that the states had agreed to with regard to the take title provision. And that's why it was a totally different set of federalism issues. That if the states had simply said, we agree to this, and we agree to the following consequences, and it's going to be enforceable in federal courts.
Here's the salient difference with respect to states' rights to choose its electors. The Supreme Court, in a couple of cases, McPherson versus Blacker in 1892, Bush versus Palm Beach County, unanimous per curiam opinion. That's the decision that preceded the second go-round of Bush versus Gore. Held that this specific power is a power that cannot be given away. It can be reclaimed at any time. It is bound only by Congress's power. Congress can say when the date is for choosing electors, but they can never keep a state legislature from prescribing the means of its life. Now, I'm not sure that's a huge problem, because I don't think anybody would really, they're sitting there 6 months out figuring out, let's see, which way is our state? Is our state going to tilt the Electoral College one way or another if we get it out? But it is possible, and I think the real barrier is, would knowing the possible compact clause or the unenforceability of this, would that deter states?
At the front end.
But here's a question.
But let me just deal with that.
Okay.
McPherson versus Blacker and Bush versus Gore, they're very different. In those cases, it was somebody other than the legislature that was arguably impairing the legislature's decision. And Chief Justice Rehnquist wrote a dissent from denial cert in Salazar, which is a case where Colorado courts were doing the redistricting in Colorado. And there was an objection under Article 1, Section 4, which also gives the state legislatures, distinctively, the power. And the question there was whether the courts could engage in this districting or whether that violated Article 1. And the court denied cert. Rehnquist wrote a dissent from denial in which he said, what the courts are doing does not owe to any decision made by the legislature or the people of the state. So I would say, Article 2 says the state legislature shall prescribe. The state legislature has prescribed when it enters into the agreement. And just like it's not a violation of the 13th Amendment to specifically perform a contract, it's not a violation of each state's autonomy to enforce what they said they wanted to do.
Can a state make a rock so big it can't move it? I mean, actually, that's a variation of the issue. You say this is a power of the state legislature. I actually agree with that. But it isn't a power of the state legislature that one state legislature can take in such a fashion as to bar future contrary action by a subsequent state legislature.
What if the state legislature decides to come to a contract to spend billions of dollars in conjunction with other states?
There's some steps that can't be taken backwards, but this one, constitutionally, always has to be. But let me get my question out. This can become the first question from the audience, okay? Because I share a lot of these. I'm very attracted to this idea of collective action by the states within their constitutional powers to accomplish an unexpected result that's more majoritarian and more democratic. If you object on democracy grounds to the Electoral College, you really have to object on democracy grounds to the U.S. Senate, of course, right? Here's my question. It's just an idea. I have no idea whether you can do this. Could the Senate, if you got a majority of senators to agree, vote to change its rules so as to give California senators 24 votes on Senate consideration of resolution? In other words, could the Senate, by rule, decide to apportion it itself as a matter of the effective voting power of its members, according to strict majority? In other words, if you can do this workaround with the Electoral College, and I think you can, could you do it with the Senate?
Well, I haven't given a lot of thought to that. I mean, I don't
Do you like this idea?
Well, is there anything in the Constitution that says each senator gets one vote?
No, it says that no state can be deprived of its equal suffrage in the
without
Senate.
consent.
But the Senate has the power to make its own rules of proceedings.
Right,
The
but-
Senate could say whatever Majority Leader Reid says is our enacted law.
Even
As a
if-
matter of its own procedures.
But even if that ends up depriving a state of its equal suffrage in the Senate?
No, they're there, and they voted by majority vote for the rule that they would now be voting to give Harry Reid all power. So I'm just wondering, if you are concerned about it, if you think, oh, that would be subverting the Constitution, then you understand better the objections of people who think.
Any way to get, the Senate is an absurd idea in the 21st century. I mean, who would structure a system where California and Wyoming have the same, representation?
Wyoming.
Exactly. So
Arizona would.
I mean, to me, the genius of the Senate was the indirect election part.
Which is gone.
Which is gone now. So I don't know
Much
if
with the Electoral College
workaround would work. Again, it all would depend on what that clause that protected each state from denial of equal suffrage without its consent would be. I'd have to research that.
Okay, do that.
I hate to interrupt, but we're going to try to get some questions from the audience. Does anybody have a question?
Well, I guess I have two quick questions. The first one is essentially, why would a state, this is for Mr. Amar, why would a state want to give up their massive influence on the national election? Why would California, for instance, or Florida want to say, you know, our citizens are very important and right now we're a national focus and the president would cater directly to us. Let me give that away. What is the purpose? How are you getting these people to sign these things?
Well, the appeal of the national popular vote system to me is the one person, one vote commitment to a democracy ideal. In practice, I think states that are doing it for a mixture of reasons, some of which are laudable, but some of which are self-interested. Because as Mike pointed out, California and Texas may have clout in the national election in certain respects, but not in others, because they don't get any attention during the campaign. The candidates don't come make promises that are relevant to the median voters in those states, because those states can be taken for granted in one column or the other. The Electoral College, it turns out, Mike mentioned the preference for small states, and that's often invoked. It turns out the Electoral College doesn't really help small states very much. And the reason for that is because the winner-take-all system that almost all states have used to allocate their electors means that the states that matter are the ones with a chunk of electors that are purple. No campaign. There's only been 2 presidents in U.S. history who come from small states: Franklin Pierce from New Hampshire and Bill Clinton from Arkansas. And none of the campaigns focus on small states. They focus on Ohio, Virginia, Florida, Pennsylvania,
New Mexico,
Wisconsin, New Mexico a little bit, but again, in a super tight presidential election, every vote, every state counts, and then every purple state counts at that level. But so a lot of states. Why Jan Brewer is open to this is because Arizona will get more attention and thus more promises that the candidate who wins will have a need to fulfill, even if the promises were made for the wrong reasons.
Yeah, I actually agree that the relevant distinction is not large state, small state, red state, blue state. It's purple state.
Swing state.
Purple state versus primary colors.
Now, interestingly, by the way, if that is the real reason a lot of states join onto it, to enhance their clout vis-a-vis other states in this zero-sum campaign game, that might argue in favor of a requirement of congressional approval for purposes of the Compact Clause. Because what the Supreme Court has said is the Compact Clause is about making sure states don't do things that hurt other states without congressional approval. To the extent that states join on to this just because they believe in one person, one vote, that would be one thing. But to the extent that they join on because they're trying to get more play, then I think that's an argument that the Supreme Court might use to say congressional approval is required here under the Compact Clause.
I'd like the question for someone else.
Any others?
Could a state then decide to just distribute its electors proportionally? As to, so Arizona could vote both ways?
Certainly.
Proportionally.
Yeah,
And
constitutionally, absolutely. And I think there are movements underfoot in some blue states
Or the red state legislature.
with red state legislatures to do exactly that, right? You know, if it's close in Ohio, why should Obama get all the votes in Ohio and Pennsylvania and Wisconsin, or at least talking about the idea of distributing their electors proportionately or by districts. 2 states do it by district. Maine and Nebraska do it by congressional district.
Yeah, now, so a couple points about that. Maine and Nebraska do it the way where it says every congressional district winner in the present race picks up 1 electoral vote corresponding to that congressional district, and the person with the most votes statewide picks up the extra 2, the 2 that come from having 2 senators, the bounty. Maine and Nebraska are both small states with 2 and 3 congressional districts respectively. So at least the winner of the popular vote is guaranteed to get a majority of that state's electors, because if you win the state popular vote and pick up a bounty of 2, you had to win at least 1 of the state's 2 or 3 congressional districts. Now you can't win the statewide vote and lose all 3 districts. In places like Pennsylvania, you could win the state's popular vote and get many fewer electoral votes than your opponent because of district gerrymandering, packing all the Dems into a few congressional districts. And so statewide, the Dems could win big. Now, so in 2011, the year before the 2012 election, Pennsylvania legislature, Republican legislature, tried to change to a proportional system. And Nebraska tried to go to winner take all, because Obama picked up Omaha and the congressional district that it was in 2008. They wanted to deprive him of that 1 single elector. So they said, let's go winner take all. These things are constitutional. They are dirty. They're beneath people like Mike, I think. As I said, these are we should not pick the rules for the presidential election based on partisan, party-focused objectives.
Yeah, I don't know that anything is beneath me. Actually, the core point is that constitutionally a state can do what it wants. And this
No, the core point is that those things failed because they looked so bad to the state and to the nation. That's the core point. That when they were exposed to the light of day, people thought that they were not worthy of the United States.
Well, let me explain the game theory aspect, because it goes back to the preceding question. Why would a state do that? Why would a state make itself less powerful by getting rid of winner take all? And the idea there is, well, that they somehow think that proportional representation is at some level more fair. Which actually is the same intuition as the national population.
If it were done writ large, and it still doesn't work because congressional districts are of different sizes, so it still doesn't quite work.
But actually, that inspires a different question for me. Okay? This system works as long as every state is exercising its power to prescribe the manner of elections in the form of having an election by popular vote. There's nothing in the Constitution that requires that. Suppose you're a state that hates this idea for whatever reason. Suppose you're Wyoming. Wyoming could thwart the whole national popular vote plan by saying, okay, the hell with you. We're not having a popular vote.
Or we're not reporting
We're not reporting our scores.
our scores.
There is no national popular vote. Ha, 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 California. We're just appointing our electors by the state legislature. There's nothing constitutionally that would protect that. How do you guard against the specter of obstructionist, anti-NPV states?
I adverted to that early on with respect to the recount. Kind of a variant on this hypothetical is, let's say there's a nationally close popular election, but some states where the vote wasn't close don't want to participate in a national recount. Wouldn't that undermine the legitimacy of the recount that's done in some, but not all states of the country? I adverted that earlier. That's one of the 2 reasons why I think congressional approval and congressional involvement is needed to make this plan free from disaster. Because I think Congress has the power to set up a system of a national poll in each state, whether or not the dissenting states want to use that tally for purposes of their allocating their
Wait,
electors.
Congress can mandate that a state use a popular vote?
No, they can mandate that there be a poll. But Mike, I gave you my read. Just read it. You kept saying you're going to read it.
I read it.
No, you didn't read it. Because if you did, you know. And don't tell me you read it. Don't lie to me. Because I laid out very clear exactly what they did.
I read it. I'm just mirthfully thinking that's a huge problem. That I don't see where the you have four arguments why Congress has the power to do this, but I don't buy any of them. If the state has the constitutional power to choose the manner of electors, I don't see what is the source of the congressional power to mandate that there be a national presidential election, or even worse, this is more troubling, that there be a poll, a beauty contest that would then provide the basis for this.
Where does Congress get the power to require states to allow voters in the presidential election to register at the DMV if a state didn't want to do it? Motor Voter says a state must allow people to register for the presidential election held in that state by DMV whether they want to or not. And the courts have upheld that.
Oh, what is that? Is it necessary and proper to which power?
To Congress's power to prescribe congressional elections. And hold the presidential elections on the same day.
Can it mandate a presidential opinion poll?
Read Posner's opinion.
See, the problem is it seems more and more jerry-rigged once you do that, and it seems to, I like the idea in concept as long as it is an exercise of the state power. The whole purpose of the Electoral College system was to cut Congress out of the loop so that you wouldn't have a system where the president was in any way beholden to selection mechanisms prescribed by Congress.
Well, but the court has upheld lots of congressional regulations of federal presidential campaigns. Buckley v. Vallejo, campaign finance. What if a state says, we don't mind a little fraud in our election to pick our electors?
Well, we call that state Illinois.
We call it Illinois. So we don't like these feds telling the candidates what they can do when they campaign for president in Illinois. Supreme Court says the federal government has that power.
Okay, we got one last question.
Oh, more than that.
Okay, this is going to adjust things, and I'm reluctant to do this because I really am enjoying listening to two people talk at the same time when it's not me that's one of them. But I think there's actually, and this gets away from what I'm actually really interested in about the implications of trying to implement this, but I think there is a justification for the Electoral College that neither of you have really gotten into, and I thought I ought to throw it out and see what your response to it is. And it really is because the failure where popular election falls apart is with a tie. And it happens from time to time. And you see these quaint little articles in some city where there was a tie, and so it was decided on the basis of draw poker.
Or a coin toss.
Or a coin toss. Now, that's a problem if it's the President of the United States. And that's combined with another problem, which is human beings have terrible difficulty with statistical significance. And if there is a large number, and a large number is better than a less large number, the large number wins regardless of the statistical significance. And if you want proof of that, you need to go no further than how law schools use the LSAT score. So what the advantage in the end of the Electoral College is, apart from how it came about and what its use was for, which is horrible, is it's a tiebreaker. And it's a tiebreaker in a lot of situations where, yes, somebody wins by 40,000 votes, and that sounds like a lot. But in the context of the United States, in the context of the number of people voting and the inability of humans to perceive what 40,000 people actually is, what you really have in a lot of these elections is a statistical tie. Now, what are you going to do in that situation? And what we resort to is, yeah, but the bigger number is better than the smaller number. So in some of these situations, the Electoral College is seriously flawed in a lot of ways, but it's a tiebreaker. And it is a two-part tiebreaker which has real virtue, which is Okay, when it is a close election, if it's a landslide election, it doesn't matter. You win with the popular, you win with the Electoral College, it's a non-issue. If it is a close election, maybe we ought to look at something else rather than just our idea that 4 is bigger than 3. And the first thing you do is you look at the Electoral College. And if you can't get resolution there, then at least the President of the United States is decided in the House of Representatives rather than being decided by where the end result is of a popular vote, which is a coin flip or the poker draw or whatever it is.
I was going to say, the Electoral College can end up in a tie much more likely than a national popular vote. You could have someone win the national popular vote by a couple million votes, which is a significant difference. And yet you could have an Electoral College tie. So I understand that the ties are uncomfortable, but having an Electoral College increases the likelihood that you're going to have a first level tie. And then go into the House where every state gets a single voice. And there are no rules for that either. I mean, what do you have in states that have an even number of congresspersons? And what if they are deadlocked? There's no way. So I'm just not sure that the Electoral College is the right way. I mean, as arbitrary as better beats smaller is, that's one person, one vote. You know, when the Yankees won the World Series in Game 7, 11-10, you know, 11 is better than 10, and we don't say that, well, there was no winner. Right?
Yeah, I actually agree with that. You know, there are statistical dead heats, but in the end, our intuition that bigger is better than smaller is a better intuition. You know, the problem lies sometimes in this idea of how you conduct a national recount. You know, I understand that the scariness of the proposition, but I think that's a better solution. I don't think the Electoral College system is justified solely on that sort of rationale as a necessary tiebreaker, because it can misfire and it serves not to break a tie, but to award the win to the loser.
Okay, with that, we're going to have to conclude because our speakers have to catch a flight. But thank you all for coming, and if you give our speakers